An Illinois Supreme Court decision could be coming on the state's gun ban when it comes to a temporary restraining order from Effingham County. That's after the Illinois Attorney General said that they will ask for an expedited schedule to address the TRO that a Fifth Circuit court has upheld from Effingham County. The latest here now with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Springfield's news and talk, and a lot to tackle, including getting the immediate reaction of Attorney Thomas DeVore, who secured that TRO in Effingham County on January 20th, and then appealed by the Attorney General. DeVore responded in the Fifth Circuit, and the Fifth Circuit Appellate Court yesterday issuing a ruling, which we'll go through in just a little bit of detail here, but essentially upholding the TRO moving forward. And now the case is going to go back to Effingham County for a potential trial, but you also have the Illinois Attorney General motioning to get this in front of the Supreme Court in an expedited fashion. So we'll hear from Attorney Thomas DeVore coming up. Chatted with him yesterday after the appeal was rejected essentially by the appellate court. But also we'll hear from some lawmakers I was able to get in front of. But I also want to hear from you at 217-629-7970. That's the phone number here, live and local on WMAY. I'm Greg Bishop. You can follow along, Bishop on Air, Twitter, Facebook, Instagram, YouTube. Best ways to do it, though, either here on YouTube or on Twitter. You can message us that way. Just search Bishop on Air, and we can make that happen. But again, the best way to connect is live on the air at the phone. It's 217-629-7970. That's the phone number. You can call in live and local. But I want to, of course, break down some of the latest in the gun cases. Now, just to reiterate, we've got 9 different cases that we're watching to see how they go in challenging the state's gun ban, because the state enacted a ban on certain semi-automatic weapons January 10th. They also banned the future sale and possession of certain magazine capacities of more than 10 rounds for rifles and more than 15 rounds for handguns. Plus, you've got a gun registry that the state law creates that the window for that opens October 1st, and you have to register your previously owned firearms by January 1st. So if you have guns before the ban that fit this category defined by the General Assembly as assault weapons, then you have to register those with Illinois State Police. Still getting more detail and calling around and trying to find out how this has been enforced thus far. We, of course, found out this week confirmation from the Illinois State Police that they did conduct at least one enforcement detail against a business they said was advertising publicly the sale of banned weapons, and they took enforcement action, but we have yet to get any specific detail on that. Seeing all kinds of things online, but of course we want to get the official word before we report that out, so we'll continue to work on that. But all these different lawsuits, you've got multiple lawsuits in federal court. One that's filed by the Illinois State Rifle Association, another filed by a group, Illinois Gun Rights Alliance, another filed by the National Shooting Sports Foundation. You had a Crawford County state-level court case that was transferred to federal courts, so that you've got that one as well. Illinois State Police are looking to combine those 3 into the Crawford County case. We had a judge selected that was an Obama appointee in that consolidation request, but that judge transferred it to a Trump-appointed judge who was handling the ISRA case and the Federal Firearms Licensees of Illinois case. So the federal judge that was appointed by Trump is going to oversee those cases. But you also have the McHenry County state-level case that was transferred to federal courts. So whether or not that's going to be lumped into with these series of other cases, we'll see. Still pending, we have a temporary restraining order in federal courts pending a ruling, and that's out of the Naperville challenge. But you also have a state-level court case in White County from Attorney Thomas DeVore, where we could see a temporary restraining order ruling in the days ahead. So those are just a slew of some of the other cases. You've got another case over in Macon County, state-level court from State Representative Dan Calkins. They're actually going to have a hearing on that Friday afternoon, so we'll be covering that as well. But to the Effingham County case, which was the second state-level case, but the first one to get an emergency hearing, and they had that hearing the Wednesday before the 20th. Then Friday, you had the ruling come out. The Effingham County judge issuing a temporary restraining order on behalf of 866 plaintiffs that sued, meaning the state could not enforce the gun ban on those 866 individuals, several of which were owners of gun stores. So with that restraining order in place from the state being able to enforce that, those individuals could voluntarily go into and exchange money for guns and vice versa and purchase whatever firearms they wanted, like AR-15s, for instance, or semi-automatic rifles that have more than 10 rounds in a magazine. So you've got that temporary restraining order that was issued the 20th. The Illinois Attorney General appealing that in the Fifth Circuit, and then you have the Fifth Circuit yesterday issuing their ruling where they essentially upheld one of 4 counts. And I do want to go through this a little bit, and you can see this, of course, at the Fifth Appellate Court website, where you've got the long 866 plaintiffs. But the court of 3 justices on the appellate court, they analyzed everything. They took all the arguments in the briefs and unpacked it. You had a split decision here among the 3 justices. You had the justices, 2 of which were the majority opinion, siding with upholding the TRO, while a dissenting judge saying that they disagreed. But just to go through some of the arguments here, there were 4 counts that they reviewed. One dealt with the alleged violation of the single subject rule. And what this is, I'm going to do my best to explain this. I'm not a lawyer, but my best to explain this as I track what happens at the State House as a reporter. But the single subject rule deals with, legislation should deal with one subject. And typically when they file a bill, it'll say House Bill 1472, and it says amusement park rides. That's the subject it should deal with, according to the charge. But typically, lawmakers regularly go in and they strip that bill and replace a bill that's supposed to be about amusement rides and make it about banning weapons. So you can see how some may say that's a violation of the single subject rule. That happens all the time in the State House, especially at the tail end of any particular session, like we saw with lame duck session multiple times. But the Fifth District Appellate Court threw that out, said, no, that's not relevant. The second charge that Attorney Thomas DeVore brought was the violation of the 3 readings rule that they alleged. And that's where you have to read a piece of legislation 3 days, 3 separate days, and it can be just House Bill 1472, a bill about amusement parks. And then the next day, House Bill 1472, this is second reading. House Bill 1472, this is third reading and final passage before it goes to the next chamber. The appellate court essentially threw that charge out as well, saying that's not relevant. So then they get to count 3, and there they say that the plaintiffs alleged that the passage of the act, the gun ban, violated due process as required by the state constitution that allows for meaningful opportunity to participate in the passage of the act. So the justices said, no, that's not relevant either. The count that they let stick, that Attorney Thomas DeVore really put on heavy, was the allegation that this violated the Equal Protections Clause of your rights, meaning if you, as an individual who have constitutional civil rights of free speech, freedom of the press, freedom of assembly, the Second Amendment right to keep and bear arms, and so on, if any of those rights are going to be curtailed, there has to be a very strict standard that needs to be reached. And DeVore arguing in court that strict standard is not evident in this. So count 4, the alleged violation of equal protections, that was upheld, and that's where we get the TRO that's upheld by the Fifth Circuit Court of Appeals. What is that issue of the equal protections? Well, I talked with Attorney Thomas DeVore yesterday, and he lays out some of that argument, and we'll hear that coming up here, so stay tuned. We've been reviewing some of the ruling that came out yesterday from the Fifth Circuit Court of Appeals in Illinois over the Effingham challenge of the state's gun ban. And it was a split court decision. There's 3 justices that were part of this panel, and the 2 prevailing justices essentially said there were 4 counts. Of those 4 counts, one was the single subject rule. They tossed that. Another was the alleged violation of the 3 readings rule. They tossed that. One other violation that was alleged was the lack of due process to be able to add input to the bill. The justices tossed that. The count that they let stand, Attorney Thomas DeVore has said, is the most significant count against this bill, against this law that bans firearms, is equal protections. And the equal protections argument circles around the fact that those who are not required to comply with the gun ban and the gun registry are current and retired law enforcement, security guards, wardens, jailers, hired security contractors. So anybody who is in the law enforcement or security industry was exempt from this law. So they could still go out and purchase semi-automatic rifles and magazines over a certain capacity, but they also didn't have to register those. They could if they wanted to, but they didn't have to. So some of the arguments we'll hear from Attorney Thomas DeVore coming up about why that's so crucial in this argument about the ban on certain types of weapons, and what was some of the arguments that the state provided as to why they carved out those industries to be exempt from having to comply with the weapons ban and the registry. So we'll get to more of that coming up, but I did want to touch on just one issue that was brought up by the dissenting justice. So again, 3-judge panel, 2 justices in the Fifth Circuit Court of Appeals for Illinois sided with DeVore on one of 4 counts, which DeVore says is the most significant one, the equal protections violation. But the 3rd justice, the dissenting justice, laid out his rationale for why he's a dissenting justice in this. And, it's, of course, a lot of legalese that they spell out. But what's interesting is the aspect of just how the argument of equal protections it's not necessarily comport with the Illinois Constitution. So, after breaking down some of the arguments, the dissenting justice said that leaves only the protection offered by the Illinois Constitution, which he says does not afford the plaintiffs a fundamental right and does not entitle them to strict scrutiny analysis of their count 4 equal protection claim. So interesting to see that, and just exactly what happens next with this, we'll be watching closely. But the Illinois Attorney General has already said that they are going to request an expedited review of the Fifth Circuit Court of Appeals' decision to uphold a temporary restraining order for the 866 plaintiffs in this case, and they're going to have the Illinois Supreme Court try to get that expedited schedule to review. Outside of that, it goes back to Effingham County. So the temporary restraining order is temporary, right? It's just saying, hey, hold this. We're not doing this law until we hash out all these arguments. So now it goes back to the circuit court, where they likely are going to have a trial about this, unless the Illinois Supreme Court comes in and intervenes in some way. We'll be watching that. But you've also got the outstanding pending rulings on TROs out of White County, and how this upholding of the TRO in Effingham County by the Fifth Circuit, how that could actually be extrapolated out to other counties, say in Macon County, that we're going to have a hearing Friday, or in White County, or say there's another lawsuit that's brought up using very similar arguments down in Effingham, using those arguments in different counties, Coles County or Sangamon County or even Cook County. We'll see what happens with all of these potential ramifications from the Fifth Circuit Court of Appeals decision yesterday. But much more coming up, including your phone calls at 217-629-7970. But up next, I am going to share with you some of the conversation I had with Tom DeVore, so be sure to come back.